We'll call the special committee on restricted driving privileges interim to order, and thank you for being here. I did receive a text from Senator Bowers, and she, due to personal matters, has chosen to be on WebEx today, so she'll be setting in. Again, welcome to everyone here. I appreciate very much the conversation and the breadth of information that we received at the last interim. I think it started off at a perfect pace. And I think we recognize, of course, that this issue is broader than just Senate Bill 2. It's a very complex issue. And today we'll try to get into work through with the conferees questions and make some final recommendations. This is not a legislative committee, but we do and are able to make policy choices and recommendations for when a bill is written later by someone that chooses to carry the bill. And so it's an opportunity to explore different avenues. Some of these areas that we talked about, of course, we found out that maybe we don't have enough information. Maybe some of these areas will require another special committee or possibly a recommendation to the Judicial Council that these issues be studied in much more in depth. So with that, we'll kick off. By the way, while I think of it, committee, be sure and sign your payment vouchers and move them forward if you care to get reimbursed. And if you don't care to get reimbursed, that's okay, I guess. Okay, first thing on the agenda this morning, and again, I want to thank this staff. Anybody that works in the Kansas Legislature recognizes how valuable and how professional our staffs are, and this is no exception. We'll open it up to Eric and follow-up information on previous meetings. You have the floor, sir. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Eric Adell with the Kansas Legislative Research Department. I've got a number of documents in front of you that I'm going to go through and then provide some additional information in response to some of the information that was requested by the members of the committee at the previous meeting. And I'm also going to just sort of review some of the recommendations that the committee and previous conferees had made. And then I'll get into addressing some of the information that was requested by you all. So I'm going to start with a document in your packet entitled Committee Requests for Information, Committee Suggestions, and Conferee Recommendations. And just contains a summary of some of the information from the previous meeting on August 29th. So information that was specifically requested by the committee included how other states send out suspension notices, which traffic citations could be excluded from suspension for failure to comply. So those were in reference to the statute, KSA 8-2110, there's reference to not appearing in court or complying with the terms of a traffic citation, and as traffic citation is defined in statute, it provides for the types of offenses that can be that can lead to a suspension if you don't pay in a district or municipal court. And Adam Siebers with the Revisor's Office is going to go through that list of citations a little bit later. Additional information requested included how other states have implemented payment plans, how Kansas courts currently utilize payment plans, what differences between suspension and revocation are in current law and administrative practice, and additional data that would help provide clarification of the population of interest for this reform. Other in committee discussion, some of the other suggestions that were made by committee members to consider a review included considering a change in the suspension process to allow for an initial period in which a person's driver's license would not be immediately suspended. That was a suggestion that was made by Ed Klump, one of the conferees. Exploring the possibility of providing for repayment plans and improved communication between the Department of Revenue and the courts. Reviewing traffic citations that could be excluded from citations that, if not paid, could result in a driver's license suspension. Considering limiting reinstatement fees to a single administrative fee per reinstatement rather than a reinstatement fee for each charge associated with the failure to comply with a citation. Consider providing judicial discretion with regard to suspension and revocation, and reviewing the requirement that certain drivers maintain SR22 insurance. And then recommendations that were made by conferees. The chair asked us to provide a list of those things just to remind the committee of some of the things that were suggested by the conferees during their testimony. And there were a number of suggestions, and we have them organized by the category of what the suggestion is pertinent to. So with regard to SB2, suggestions were made to clarify language in SB2 as to whether habitual violators would be included. Include in SB2 cross-references to relevant statutes, so it's clear who the population is that the statute would apply to. And then with regard to fines and fees, recommendations were made to establish a historical cutoff of outstanding fees, so not allowing citations to remain on one's record indefinitely in certain cases. Requiring courts to notify the Kansas Department of Revenue of failure to comply with a citation, making that discretionary instead of mandatory. Changing language requiring payment of all fines, court costs, and penalties within 30 days of notice to payment of fines as ordered by the court. That suggestion would allow for some discretion of courts to order payment plans or fines that differed from than the total of all fines. And I think that courts have that discretion in 8-2110 already, which I think I'll talk about in a little bit. Limiting reinstatement fees to a single fee per reinstatement rather than a fee for each charge. Or minimally limiting reinstatement fees to only charges resulting in a conviction. As it currently is written, 8-2110 mentions all charges that are associated with the original citation. And so in cases where someone maybe eventually had some of those charges dismissed, it's not clear that those wouldn't be included in things that would still apply or need to be paid, or that would require a reinstatement fee. Reviewing the requirement for anyone convicted of driving while suspended to maintain SR22 insurance continuously for 12 months. There's some question about whether it's permissible for, whether that should apply to anyone, regardless of whether they already have sufficient insurance. Consider expanding restricted driving privileges to individuals whose licenses are administratively suspended for driving without insurance. And then with respect to penalties and sentencing, it was recommended to make suspensions less punitive by removing mandatory sentencing, removing mandatory minimum jail sentences for second and third convictions of driving while suspended, but providing for some sort of mandatory fine. Removing the mandatory 90-day suspension extension for driving while suspended. Removing the forever look back of offenses by allowing offenses to roll off one's record eventually, providing additional legislative clarity as to what constitutes manifest hardship. And then with respect to license restrictions in general, it was recommended to provide restricted driver's licenses for drivers who are making attempts to comply and be accountable, limiting the number of opportunities that an individual has to apply for restrictions, reforming law pertaining to failure to comply to begin with restrictions and then have suspension be subsequent to continued noncompliance. And then additional recommendations included reviewing traffic violations that could be excluded for grounds for suspension for failure to comply, focusing on preventing revocation and perpetual suspension status rather than dealing with the after effects, providing funding for license reinstatement clinics, and improving data transparency from the Department of Revenue. I'll stand for any questions regarding those points if anyone has them at this time.
Yes, the chair recognizes Representative Carlin.
Thank you, Mr. Chair. I have never really heard the term SR 22 insurance. Would you please describe that for me?
SR 22 is a form that's required to be maintained on file with the Department of Revenue, is my understanding. It's not a different type of insurance, but it's just something that requires a bit more administration. And so as a result, premiums tend to be higher, or probably are always higher for individuals that have to maintain SR 22 insurance because of the additional administration. And it's usually associated with higher, more serious offenses.
Mr. Chair, I'm not clear yet what that is. Is it just, is it an insurance policy or is it an affidavit type?
It is a requirement by the Department of Motor Vehicles. It comes under the statutes, if I'm not mistaken. Eric, you correct me, and under financial responsibility.
It's a way of guaranteeing that you're maintaining financial responsibility where there is more oversight with the administrative department rather than just carrying. It's something that can be checked with Department of Revenue. We do have people from the Department of Revenue here that if it's still unclear, this is not my area of expertise, so they might be better equipped to answer that question later.
Thank you, Mr. Chair. Also, then do they buy this or is this just an informational piece?
If I may suggest this, Representative Carlin, let's wait till we get to the recommendations sections,
That would be fine.
because the Department of Revenue is here. We have a number of conferees in the audience that are available to answer questions at the right time. Thank you.
Thank you. Thank you, Mr. Chair.
Chair recognizes Senator Faust.
Chairman, so to respond to that question by Representative Sidney Carland, I know individuals that are required to have the SR 22 and they're not even driving a vehicle. They walk or ride a bicycle or take a Uber, but they're required to have that insurance. And some of them also are still paying insurance on their vehicle. So it's an additional requirement of additional insurance that they have to pay when they get into the status of suspended or revoked driver's licenses. Thank you, Mr. Chairman.
Are there any other questions from the presenter? Seeing none, we'll proceed on.
So what I'd like to do is go back to the beginning of that document where there's the list of information specifically requested by the committee. So that's how I think I'm going to organize my time, is to just try my best to address these questions myself and the revisor's office as well. So we do have a document in your packet. The next one is how states send out notice of suspension or revocation. So KLRD reviewed state statutes pertaining to sending notice or providing notice of license suspension or revocation. And we just sort of noted anything that differed from Kansas that we were able to identify. This may not be an exhaustive list. We did our best to identify these differences, but there are likely other things that states do that differ from what Kansas does. So in general, states require providing notice by mail. There is pretty well-established case law for the conditions under which notice is sufficient. And so in general, states are providing notice to individuals by mail. And then states may differ in terms of, depending on the gravity of the offense, they may require it be by certified mail. Sometimes states will have that in cases of notice of suspension due to missed child support payments. They might require notification by certified mail. And then states also sometimes have requirements for record keeping of the notice of suspension in case anything were to go to court for somebody claiming that they hadn't been provided with notice. But in general, states are mailing to an address that they have on file. The biggest difference that we found is that states differ with respect to who's providing the address. So in Kansas, the address is what is on file with the Department of Revenue. That's pretty common across states. Typically, it's required that notice be provided to the address that's on file with the administrative agency responsible for driver's license administration. In some places, you have mailed to the last and usual place of abode. In Massachusetts, other common destinations are the address that's shown on the law enforcement officer report. So some states actually require both if the address differs from what is on file and what's on file with the administrative agency and what is contained in the officer's report, whether it's an accident report or a ticket. The two states that require both of the mailing of notice to both the address that's on file and the address that's in an officer's report are Colorado and Maine. And then in Maine, they also they require certain offenses the address on record with the Secretary of State. In Arkansas, courts are directed to provide an address that they have on file to the administrative agency. And then California just states it can be mailed to a more recent address as reported by a person, court, or police during proceedings. And then in a number of states, notice is said to be sufficient if it's delivered in person by a law enforcement officer or other official. And we actually found other states that would fall into this category where specifically in statute, it says that the receipt of a ticket that says that you're required to appear in court in person constitutes notice. And I think that states have been directed by some court decisions that may not exactly constitute sufficient notice, but states do have that provision where the information that's provided on the ticket is intended to be providing notice to the person that their license may be suspended if they don't comply with the citation. And then in two states, California and Texas, they allow email to the most recent email address if the person has opted into electronic delivery. And the opting into electronic delivery is taking place at the time when they apply for or renew their driver's license. And then in Georgia, the agency is authorized to use data from the U.S. Postal Service, their new address data. In California, they're authorized to use any alternative means to identify the address. And also, they have a administrative requirement that notice is not, that notice isn't, cannot be returned as undeliverable or unclaimed, that they have to try again if they receive that notice. And then in cases where they have to make additional expenses in California to provide notice, they are given the authority to provide, to require a fee to recover those costs. And I'll stand for any questions about this issue.
Are there any questions? Chair recognizes Senator from Sedgwick, Senator Pascal.
Thank you, Mr. Chairman. Eric, in Montana, the 3 bullet points listed here that says if the motorist can provide proof of insurance, is that the regular, are they asking for the regular insurance that we all pay on our car, or are they asking for the SR-22 insurance?
Were you referring to a particular document? I'm sorry.
Yes. So you've given a list of what other states are doing. Did you mention Montana?
So we don't have anything on Montana for this, but and this wouldn't have anything to do with necessarily insurance requirements. This would just be for what states do in terms of when there's a determination that a license is going to be suspended or revoked. How do they require the state to notify the individual who's going to have their...
Thank you. So it didn't include any other requirement other than just notification?
Not in this,
okay, thank
not
you.
with respect to this.
Thank you.
Committee, are there other questions from Eric at this time as it pertains to the notice of mailings? Seeing none, you may proceed, sir.
Thank you, Mr. Chairman. So moving on, which traffic citations could be excluded from suspension for failure to comply. I'll ask Adam to come up in a minute. Here in a little while. So I'll move on from that, but I'll move on to how other states have implemented payment plans. The next document in your packet is titled State Statutes and Legislation Establishing Payment Plans for Debts Related to License Suspension or Revocation. So again, KLRD reviewed statutes and recent legislation in as many states as we could find that are approaching this issue with regard to providing payment plans for traffic-related debt. And so the document in front of you has them organized by state in alphabetical order, and we just sort of pulled out, tried to summarize the sort of key points of either new legislation or existing law. And in Kansas, there are currently no statutory directives requiring courts to establish payment plans. However, this was pointed out in response by the judicial branch in our correspondence that KSA 2110 establishes procedures for suspension of driving privileges for failure to comply with a traffic citation, but it permits courts to modify the method of payment of fees, fines, and court costs associated with traffic citations and license reinstatement. So there is language in that statute that permits courts to establish payment plans. And in a minute, after I get through this document, I'll talk a little bit about what Kansas courts are doing. But just to point out that as it's currently written, the statute does have language that is suggestive of providing payment plans, and it's permissive language. Just going through the list, Alabama in 2023 enacted a law that that did not require payment plans, but made a specification that if a court has required a payment plan for an individual, that they would not be able to order the suspension of their license unless that individual had missed at least 3 payments on the payment plan. So just providing some direction as to what constitutes noncompliance. Florida law requires courts to enter into payment plans sort of generally. In Florida, it's not specific to license reinstatement or license related issues, but they require courts to enter into payment plans if an individual is determined to be indigent. And recent law added some limitations to make their payment plans more affordable. They limited payment plans on debts, on the combined debt of an individual to 2% of their annual income or $25 a month, whichever is less or greater. And then it limited down payments that courts require to establish a payment plan to $100 or 10% of the amount owed, and whichever was less of those. So it limited it to $100 as a down payment. And in the law, they also included language that requires the licensing agency to work with court clerks to ensure court technology systems can be used to reinstate suspended driver's licenses upon compliance. Indiana, current law in Indiana requires courts to permit individuals owing traffic debts to apply to be placed on an installment plan. So in those cases, if a courts have to allow people to apply to be placed on an installment plan, but they have discretion to allow installment agreements and to set terms. And the suspension of driving privileges occurs if an individual defaults on the payment plan until they're back in compliance. So this is not very different from what probably happens commonly in Kansas, but there's just a little bit more statutory direction as to how payment plans operate in the courts. Louisiana law requires the licensing agency to enter into installment plans for payment of outstanding traffic fines and penalties to any individual who meets certain requirements. They have to owe $250 or more in fines or penalties, and they have to have satisfied all other conditions for reinstatement of their driver's license. They have to request the installment plan within a specified time frame, and I think that discretion is given to the courts to establish that time frame. They sign a written agreement with the administrative agency, and they waive any right to judicial or administrative review of the final sum. And then Louisiana law requires those installment plans to have a set final amount due with equal monthly installments on a scale that's determined by the total amount due. So they just have groups of total fine amounts and what the statutory maximum monthly payment is for those amounts. And then it requires that those payment agreements that failure to pay on time as agreed to can cause the whole amount to come due, where the driver has 60 days to pay or request the agreement be reinstated. And the licensing agency is allowed to grant a 60-day suspension of payments for good cause. So they're allowed to permit temporary default. And then failure to pay or request that the agreement be reinstated results in a suspension of the driver's license. So the suspension becomes contingent upon non-compliance with the payment plan and not the initial non-compliance. In Oklahoma, a recently enacted bill in 2023 requires courts to establish 72-month payment plans for defendants who cannot immediately pay fines and penalties. The law requires courts to make a determination of the defendant's ability to pay at the time of sentencing. It permits defendants to request a cost hearing for the court to determine their ability to pay and to request modification of the installment plan or reduction of waiver or amount owed. Permits courts to imprison or suspend licenses of individuals determined to be unable to pay but unwilling to pay. And then it establishes a court cost compliance program that allows counties to participate with third-party collections agencies and kind of creates a uniform system of collections. They specify a particular agent to be used by the state rather than just any collections agent, I believe. And then created a cost administration implementation committee within the judicial branch to oversee the cost compliance program. And then that committee within their judicial branch was directed to make recommendations to the legislature for changes that it deemed necessary to make to be able to administer the program. Montana law provides discretion to courts to order payment plans for traffic citations. It prohibits driver's license suspension and requires restoration of driving privileges if the individual meets certain requirements, including providing proof of insurance, they agree to a payment plan, and they don't default on their payment plan. So provided that an individual agrees to a payment plan, is able to maintain or provide proof of insurance and makes their payments, then Montana courts are not permitted to suspend licenses. And they're directed to restore driving privileges if the individual is doing those things. And then in case of default or non-payment or missing a payment, the law requires that the individual have their license suspended until they're back in compliance. Maryland, in Maryland law, the law authorizes courts to approve installment plans for payment of citations or fines imposed at a hearing or trial. Under the law, payment plans constitute compliance with a traffic citation. So statute specifically says that if someone is participating in a payment plan, they're in compliance with the citation. They may be established if the total amount of fines is $150 or more and don't require minimum monthly payments. So courts are given discretion as to how long individuals pay and the amount that they pay per month. In New York, the law regarding payment plans was enacted in, I believe, 2021. Maybe 2020, but their law requires courts to offer payment plans for traffic citations. The payment plans have to have monthly payments not exceeding 2% of their monthly net income, or $10 per month, whichever is larger. And in the statute also requires that notification of the right to a payment plan be provided by various state officials involved in the process. But anytime a citation is issued, it requires notice that they have a right to a payment plan, and that's provided on the ticket. At the time of sentencing, they're given that notice by the courts, and in any communication concerning collection of fines or fees. So any correspondence that they have, there's a requirement that notification of a right to a payment plan be provided. In Tennessee, the law requires courts to offer payment plans based on income and ability to pay to anyone who requests a payment plan or is required to enter into one. The law also requires courts to permit modifications upon request based on changes in their financial circumstances or for good cause. It provides for an appeals process for denials of their request for modification of the payment plan. Courts are permitted to order suspension 30 days after notice of default or failure to adhere to the payment plan if the person does not come into compliance. So similar to what Kansas law currently does with suspension, except instead of making it that 30-day period of time where a person can appear in court and pay their fines, they're provided 30 days notice. Someone could appear in court, enter into a payment plan, and then at any time they default, there's another 30-day period where they have time to come into compliance, is how that would work. And then it permits the issuance of a restricted driver's license upon noncompliance with the payment plan if the person would otherwise be eligible for a driver's license. So if someone has been complying with all of the requirements by the court, they don't have outstanding offenses that need to be dealt with. If they've been on a payment plan and they miss a payment and they're, instead of being suspended, their license goes into a state of driving restrictions for a period of time. But it's only for financial noncompliance. But if there's no other reason why that individual would be ineligible for a driver's license, then the result of noncompliance begins with license restrictions before resulting in suspension. And then in West Virginia, the law requires court clerks to establish payment plans for drivers convicted of failure to respond or appear when charged with a traffic citation. It also requires that courts implement a uniform payment plan and utilize a uniform financial affidavit for payment plan requests. And the statute actually provides for the content of that form. And under West Virginia law, such repayment plans must include the number and schedule of payments, set monthly payment amounts based on $10 a month or 1/12 of their net annual income, and they are subject to modification or waiver by the court. So in just a moment, I'm going to talk a little more about Kansas courts and payment plans, but I'd be happy to answer any questions about other states' payment plans at this time.
Are there any questions, Senator Fausto?
Thank you, Mr. Chairman, and thank you, Eric. I always read ahead of things, and so the Montana question that you just presented was my question of when the courts or when the motorists with the suspended or revoked driver's license, are they required to just show proof of insurance on the vehicle that they currently drive, or are they also required to show insurance on the SR-22 insurance coverage, or did you get that information?
We didn't review specifics of insurance requirements. Just like in Kansas law, it's not all in one place. There's references to insurance requirements that are outside of the statute, and so I don't have an answer for you at this time, but I'd be happy to follow up with you on that.
Oh, okay, thank you.
Sure.
I'd appreciate that. Thank you, Mr. Chair.
Are there other questions? As you know, committee, when we were in our first day of deliverance, We found out the payment plans were a big question mark for Kansas, and Eric's prepared to go through what we do in Kansas. What we have found out, I think Eric shared with me, is that there are differences in different jurisdictions. So, Eric, if you would please proceed.
All right. So I don't have a document for you in your packet for this response, but part of the answer to what Kansas courts are doing in terms of payment plans, the answer came from correspondence with the judicial branch. The short answer is that there is discretion for courts to provide payment plans to individuals, and many Kansas courts do offer payment plans, and it's very difficult to know to what extent courts are utilizing that, apart from being, us having received specific information or what information courts provide on their websites. So part of what we did was we reviewed all of the district court websites to see if there was any information provided on payment plans, and then just did a general search for payment plan information on municipal courts. So there, just as a caveat, there is a wide variety of things that courts are likely doing, and the information that I'm giving you is sort of just anecdotal and restricted to specific instances that we were able to identify information about. So we shouldn't make any generalizations about necessarily what courts are doing. But in general, I think courts can and do provide payment plans for individuals that ask for them. I would just also point to the language in 8-2110 that I referred to, this language was added in Senate Bill 127 a couple of years ago. And regarding the request for waivers of reinstatement fees and fines and fees and court costs. So in that statute, in subsection E, a person who is assessed a reinstatement fee may petition the court that assessed the fee at any time to waive payment of the fee, any additional charge imposed pursuant to another subsection, or any portion thereof. So that language, any portion thereof, allows courts to change the total amount. And then it says, it appears to the satisfaction of the court, the payment of the amount due will impose manifest hardship on the person or the person's immediate family. The court may waive payment of all or part of the amount due or modify the method of payment. So that's the specific language that would allow courts to provide for payment plans when someone is requesting or petitioning the court. So the main the language in the section is requiring courts to allow individuals to petition the court for a waiver of fines or fees or to reduce the total amount. But it doesn't explicitly say that they're requesting payment plans. So one of the issues that came up from this, we were provided with a link to a form on the Kansas Legal Services website that provided information about how individuals could request a waiver of fines or fees pursuant to this portion of that law. And that, in general, that's the only place that court websites are directing people for information regarding process, the legal process, or how to, represent themselves or how to interact with the court. Court websites in general have links to external resources or to the judicial branch or judicial council websites. And there are forms for particular things on some of those websites, but the only place where most courts refer people to in regard to requesting modification of payment for traffic fines is Kansas Legal Services. We found 2 exceptions to that. So we reviewed the district court websites and found that Douglas County provides a form that is a petition for modification of fines and fees. And then Wichita Municipal Court also provides a similar form. So those were the only 2 the only 2 courts that we could find that provided a specific form for individuals to use to request modification of fines or fees through a court. In the response from the judicial branch that we received, the answer was sort of that some courts operate more informally with regard to payment plans than others, where some courts have specific processes in place to allow individuals to make application for payment modifications. One of the examples, Johnson County, the standard time to pay is 60 to 90 days, and the person is given a date to return if full payment has not been made by the determined date. Extensions can be granted if the person appears. However, according to the judge in Johnson County who handles the traffic docket, a person often does not appear the second time. If they fail to pay in full and do not appear to request an extension, their license would be suspended and their debt is sent to collections. And then depending on the collections agency used, the collection agency will add a fee to the balance. During COVID, Johnson County gave individuals up to a year to pay. If the fines and fees were not paid after the year, the debt was sent to collections and their driver's license was suspended. Correspondence with a judge in Sedgwick County regarding their traffic docket. Many individuals work with the district court clerk directly to set up a payment plan. And the judge, from his own records in Sedgwick County, stated he approved 755 payment plans from January 2023 to September 2023. In cases where we found specific information regarding payment plans, I think it is common for individuals to work with court clerks to request payment plans, and then also they can be ordered by the judge. With regard to municipal courts, again, we attempted to identify any courts that provided information about payment plans. In Wichita, they have specific information about their payment plans. They say that they are available upon request, and they require the defendant to pay a one-time fee of $10 as a down payment, contact the court clerk to determine what the minimum payment will be, and sign a contract regarding the plan in person. And in general, payment plans require an appearance. So for someone who has been out of compliance because they just didn't show up to court, if they wanted to establish a payment plan, obviously they would have to come to court and work with the court to establish a payment plan. In Derby, they say that payment plans are routinely used in Derby Municipal Court. They have a minimum monthly payment is generally set at $50 or an amount that will allow the balance of fines and fees to be paid in full within 10 months. In cases of significant financial hardship, the judge may authorize a monthly payment below the monthly minimum or allow community service to be performed in lieu of cash payment for fines. Lansing Municipal Court says payment plans may be available for defendants who come to the court office in person, complete a payment plan agreement, and make their first required payment. And their plan requires a minimum payment of $20 to be made twice a month. They have to discuss any payments that they're unable to make with the judge at a hearing, and that missing 3 or more regularly scheduled payments results in the account being sent to collections with an additional fee charged. Park City says that defendants with simple traffic infractions may sign payment agreements in the clerk's office without going to court. They advise that a judge may authorize payment arrangements for misdemeanor convictions. So they make a distinction. They allow the court administrative staff to establish payment plans for minor or lesser offenses, and then for misdemeanors, they say that judges have discretion to order payment plans. And then Overland Park Municipal Court generally allows partial payments and payment plan agreements. One interesting difference is that they, I think that this is pretty common practice in courts, but they have information on their website specifically about amending a traffic citation or driving while suspended charge so that it won't show up on your record. They say that in such cases, partial payments are not allowed. Cases in which defendants apply for amended or reduced charges to not appear on the driving record. In order to have the charge amended, the fines have to be paid in full within 24 hours and no partial payments are allowed. So there's a differentiation in allowing payment plans depending on what the person is seeking from the court. And then in addition to municipal courts, we reviewed the courts of the district courts websites. And as I mentioned, there's only one of those, of the 31 district courts, that explicitly provides information regarding the availability of payment plans, and that is Douglas County. And then the 4th Judicial District, which is Anderson, Coffee, Franklin, and Osage, they make available a form for petitioning the court for a payment plan. So they don't have, it's not easy to find that information, but they do have it available on their website. And then the only other distinctive information that we found, the 14th Judicial Court does not accept payments from individuals with revoked driving privileges, and immediately refers any cases with outstanding costs not paid in full within the time allotted. They send them to collections agencies. So that is the information that we have on Kansas courts. You know, the short answer is that their courts have a lot of discretion, and the way that payment plans may or may not be offered or implemented varies across the state. So happy to answer any questions that I can about that.
That was quite an extensive review of payment plans. Representative Francis.
Thank you, Mr. Chairman. So some of the testimony we heard at the last meeting where they talked about people getting 4 or 5 fines for driving while or they get a fine for driving while suspended, and it applies to each of their prior infractions. The court has the discretion to write off a portion of those fines, right?
Correct.
Okay.
Yeah, the statute allows the original fines, any fees, court costs, and reinstatement fees to be waived partially or fully.
Representative Francis.
Thank you, Mr. Chairman. So based off that testimony, some of the issues that we've heard over at the last meeting have more to do with judicial discretion than what's actually required under the law?
I mean, any instance where people are entering into payment plans or having the amounts that they owe being waived is a matter of judicial discretion.
At this time. Okay, thank you.
Are there other questions? Seeing none, you may proceed to the next topic. Thank you.
All right, thank you, Mr. Chairman. Let me see if I can. The next piece of information, there was a question about the differences between suspension and revocation in current law and administrative practice. You may remember we provided at the last meeting a definitions for license suspension and revocation. Suspension is the temporary I guess, suppression of driving privileges or the temporary removal of driving privileges that doesn't affect the status of the license. Revocation, when a license is revoked, it requires, in statute, it requires the individual to make application for a brand new license. There was testimony in the Senate Transportation Committee. At least, I'm not sure if there was a legislative post-audit report that was presented in Senate Transportation, and I'm not sure if that presentation was made elsewhere, but specifically in the meeting in Senate Transportation, the question was the post-audit division noted that there was, in their findings, not a practical administrative difference between license suspension and license revocation. In my correspondence with the Department of Revenue, that they indicated that they had not previously been really differentiating license suspension and revocation, but that they have since begun requiring individuals whose license is revoked to apply for a new license consistent with statute. So that may be a question for a Conferee later, but my understanding of the issue is that for most situations in current law, it doesn't actually make that much of a difference. But the real difference is whether or not the individual actually has to go and apply for a new license. With Senate Bill 2, as it is currently written, it would raise some questions about just how administration of allowing people with revoked licenses to have driving privileges when they no longer have a license. There would be just an administrative question of how to handle that situation. So in the event that SB2 or something like it were passed, that would be something that could be considered. Is the individual required to go and apply for a license before they have driving privileges provided to them? In my conversations with Department of Revenue, it sounds like it wouldn't, for them, it doesn't actually matter. They currently would be able to handle allowing people to have driving privileges even with their license revoked. And I asked whether that would raise any flags for law enforcement if the individual was driving with their license revoked, but the department had authorized restricted driving privileges. So they have a revoked license, but they're authorized to drive under restricted circumstances. The law enforcement would be able to see that And so it wouldn't be grounds for pulling them over, just that they have a revoked license.
Senator Falscadeau.
Thank you, Mr. Chairman. So Eric, my understanding of the intent of Senate Bill 2 was to allow those with a revoked license to be able to participate in the existing program within the Department of Revenue, where they get a restrictive license to drive while making payments on their fines. So how does that play into what you just stated?
So in SB2, the individual would apply for license restrictions if they made the requirements for those restrictions. The status of the actual license would be an administrative question that potentially there could be some guidance in statute or some clarification in statute, but the individual would be able to drive under the circumstances given by SB2, which are, if I look, it's going to or returning from the person's place of employment or schooling, in the course of employment, going to or returning from an appointment with a healthcare provider or during a medical emergency, and going to or returning from court required meetings like parole or probation meetings, drug and alcohol counseling, or anywhere else that a court might order that someone go. But yeah, so as far as the status of their license, that's sort of an administrative question. And I believe if someone had their license revoked, they would still at some point have to apply for a new license. The question would be whether that happens before the restrictions are put in place or at the time when their revocation period comes to an end.
Are there other questions? Seeing none, the next, you may go to the next item on the agenda.
Okay, at this time, I'm going to take a break and allow Adam Siebers to come up and provide a review of the citations, the list of offenses that are included in citations that can result in a suspension as a result of failing to pay or failing to comply with the citation.
Welcome, Adam, and please identify yourself.
Thank you, Mr. Chairman. Adam Siebers, Revisor of Statutes Office. As Eric stated, there's a request to kind of go through the traffic citations that could lead, or I'll call them traffic citations, that could lead to the failure to comply, suspension, and restricted driving privileges. Under Kansas law, there are many violations that could result in a suspension of license. Under the charge of this committee, we're talking about the failure to comply citation. So that in of itself is its own offense. You can get a traffic citation, they don't comply, then it leads to the failure to comply citation, which then leads to the suspension of license. And then in lieu of the suspension, these individuals can get restricted driving privileges. I just kind of wanted to familiarize what we're talking about in a specific area. Dealing with the failure to comply, we've talked a lot about KSA 8-2110, which is where the failure to comply is found in Kansas statutes. And that specifically cites that a failure to comply with a traffic citation means failure to either appear before any district or municipal court in response to a traffic citation and pay in full any fine and court costs imposed, or otherwise comply with a traffic citation as provided in 8-2118 and amendments thereto. Just so everyone's aware of, I'm including my memo that I prepared. And really what this is doing is it lays out that the failure to comply with a traffic citation. Traffic citation is a term used in a different statute, 8-2106, which lists the offenses for where a traffic citation can be issued. It gets a little complicated, but what I've done, it creates a list of all the various offenses for where a traffic citation can be listed. Most of them are under 8-2118, which is the uniform fine schedule, which lists what is most commonly thought of as traffic citations. They use the word traffic citation. Some of the offenses are not necessarily always traffic related. Most of them are traffic adjacent. There are some that are, I would agree, are probably not would not be fit necessarily under that realm of the word traffic citation. However, the first essentially 3 pages onto page 4, kind of 2/3 of the way down, those are all under the uniform fine schedule. Traffic citations, probably the most commonly one people are familiar with. 8-2106 also lists offenses included in chapter the Uniform Act of regulating traffic. These ones are not specifically identified. They're kind of peppered in throughout the statutes. I will admit there may be a few that were inadvertently left out, but it does include. I tried to go through and find the ones and list them there on page 4. 8-2106 then lists specific offenses that qualify for a traffic citation under starting on page 5 of the memo. KSA 8-2106 A2, A3, which has been repealed, then A4, A5, A6, A7, and A8. Those are all offenses that are specifically identified that a traffic citation could be issued for. And with that, I'd be happy to stand for any questions.
Are there any questions from Adam? As you can see, it's quite extensive. And if it's generated any questions, yes, Senator Fascadeau.
Thank you, Mr. Chairman, Adam, and thank you for your work over the years on this particular issue. So, in Senate Bill 2 and what we're speaking of now, relating to revoked driver's licenses, allowing those individuals to be able to drive with a restrictive license. So, when you say comply, so really for me, it initially starts out with not being able to pay that fine. So can you elaborate a little bit when your definition of comply, is it all of this, or can we just kind of narrow it down to the original reason one might snowball from that, getting a traffic violation and not complying to not make the payment, which then snowballs into the revoked status? So is the initial, I don't want to call it a crime because it's just a traffic violation, but is it the complying, is it not to make your payment or go to court to address the issue? Thank you.
Adam?
Yes. Yeah, when I say failure to comply, those are the words that are used under the statute. So I'm trying to be very particular with my language. There is actually failure to comply if you don't pay or otherwise comply, is how the term used. It creates a new charge, and that is actually a misdemeanor. So it is a criminal violation for failing to not comply with your traffic citation. So if you get an underlying traffic citation, which in most cases are not misdemeanors, they're identified as traffic citations. You don't go to court, you don't pay your fine, you then get a new charge of the failure to comply, which would then be a misdemeanor. The revoked, it does get a little tricky. Becoming a habitual violator means essentially having 3 failure to comply or found driving without a license 3 times. The crossover in this bill is really the 3rd time. So if you've done it twice, you're not a habitual violator. It's the 3rd time when you then become identified as a habitual violator, which then puts you in the revoked status. However, you would still, under this bill, technically qualify. So that's kind of the crossover there, is that third time may be the one that's causing the confusion, which puts you in the revoked status, but still would be qualifying under the restricted driving privileges.
Thank you. Thank you so much, Adam.
Are there other questions? Seeing none, we thank you for your presentation. Eric?
Thank you, Mr. Chairman. As Adam was talking and Senator Fascudo with your question, just remembering an additional point of clarification about license revocation. Specifically, the statute that Adam was mentioning as being a habitual violator. So that revocation for being a habitual violator, so having 3 or more offenses of a particular kind, that results in a 3-year period of revocation. But there are other places in statute where revocation is not required to be for 3 years, and it's I believe the statute says for at least 1 year that determines the period of other types of revocation. But when someone has their license revoked for being a habitual violator, the period of revocation is 3 years. So at this time, I have some data for you. My plan is not to go through all of this in detail. We ended up getting a lot of data. We reached out to the courts and also to Department of Revenue, and the main thing that we were trying to identify was could we get some information about what sorts of offenses people have as the underlying offense, the original offense for the ticket that then they don't pay for, and then also where is this happening? So is it in district courts? Is it in municipal courts? And where across the state is it happening? So we were able to get excellent data from both the courts and the Department of Revenue. And they were very helpful in providing this information. And so I have a document in front of you. It's data for the Special Committee on Restricted Driving Privileges. It's sort of broken into 3 parts. We got, so there's a table of contents, and at the end it has 2 appendices. One is data descriptions, and the second one is motor vehicle record codes, just for your reference. But just to sort of describe the data, we received through correspondence with the judicial branch, data on district court suspensions. So a suspension that was ordered by a district court that was sent to the Department of Revenue for failure to appear or pay. And the courts indicated that those specifically were initiated through a non-compliance process, so wouldn't include suspensions that were a result of sentencing. So the data that they have may not be totally complete in terms of the total number of suspensions, but it's fairly consistent with the information that we got from Department of Revenue. And then the judicial branch court data did not include data from Johnson County because they use their own court case management system. So when the judicial branch switched over to a new case management system, Johnson County didn't make that change. And then 2 other kind of sources of data from Department of Revenue. First was on motor vehicle records, any suspension action by the department that was taken during 2021 and 2022 by the location and court, whether it was the district court or municipal court, and the year that it took place. And then through additional correspondence with the Department of Revenue, records of that group of drivers that have a suspension action for failure to comply, we asked for any conviction on their record at any time. So that we got the number and type of violations on the motor vehicle record of individuals that have had a suspension for failure to comply, that are currently suspended for failure to comply. The important thing to note about that is that motor vehicle record retention, the retention of offenses or violations on the record is not consistent or not uniform. So what Department of Revenue categorizes as minor violations remain on the record for 3 years. Major violations remain on the record for 5 years, and major violations that are alcohol related remain on the record indefinitely. So if you notice in the data that there's, why are there so many people that have alcohol related convictions? It's partly because of that, that those offenses, even if they got it in 1970, it would have shown up in this data. So I'm just going to sort of, like I said, not go through all of this, but walk through the tables, and then I'll come back and talk about some summary statistics to give kind of an overview.
Eric, would you take one question?
Sure.
Falscado?
Thank you, Mr. Chairman. So, Eric, when you say conviction, so pertaining to a person with a suspended or revoked license, what type of conviction are you speaking of, or just what's the conviction?
It would be an offense that was adjudicated through a court, and there was a conviction determination made by a court. Does that make sense?
Yes.
Chairman, if I may, so a conviction made by the court, like what? Having your license suspended or fines imposed? I don't know anybody who's been imprisoned or jailed by it. So I was just trying to get what type of conviction. So the suspension, is that the conviction?
It's any offense. It could be for speeding. I believe it just means that the court has made a determination that a violation took place. But could be a better question for someone from the judicial branch. Okay, so pages are numbered. After the table of contents, the page 1 has a section of summary statistics, which I'll come back to in a minute. Starting on page 2, there's a table of district court suspensions sent to KDOR in 21 and 22 for failure to comply with the citation ordered by county. And then the columns show for 21 and 22. And then we have population data from the census that just shows suspensions per 1,000 residents. If you turn to page 4, there's a map that corresponds to those suspensions in 2022 by the number of per 1,000 residents. So you can see in Sedgwick County, there's 10.7 suspensions ordered by the district court for every 1,000 residents. And if you look back at the bottom of page 3, you can see the statewide total. In the rightmost column on the bottom, it shows suspensions per 1,000 residents statewide for 2022. There's 10.1. So Sedgwick County would be an example of being close to that norm. And then, you have some of the counties a little further west that have along I-70 where there are much higher numbers of suspensions being ordered by district courts. Part of that is just how offenses may be adjudicated. In some counties, there are no municipal courts that are dealing with municipal ordinance violations. So district courts may be handling offenses differently depending on the kind of the way that courts are administered in a particular place. Like in Johnson County, there are a number of large municipal courts that may not be the case in other places, and also just who is doing the law enforcement determines, I believe, whether something goes to the district court. I think that the district court handles cases that are where the law enforcement agency that makes a stop and issues a citation is the Kansas Highway Patrol. So those would all end up in the district court. So moving on from there, maybe just before I go any further, are there any questions about the data or any requests for clarification?
Senator Fauske.
Thank you, Mr. Chairman. Eric, does an individual setting up these payment plans, does it stop the suspension?
It would depend on the circumstances that someone was suspended for. If the suspension was initially for failure to comply with the citation, once that person pays the fines associated with it and they comply with the original offense, the courts are required to notify KDOR to reinstate their license.
Any other questions? Representative Anderson.
Thank you, Mr. Chairman. I guess just the obvious, what in the world's going on in Trago with 35%?
I would hesitate to draw any conclusions. One thing that you'll notice in a lot of this data is there's a lot of variation across counties. There's a lot of variation in the makeup of particular populations, and there's a lot of variation in how how law enforcement operates and how the courts operate. So, it's really difficult to draw any kind of solid conclusions about why that's the case. I would note that Trego County has their population is 2,700. But the volume of traffic going through Trego County is much greater on any given day, I would assume. So that may have something to do with that. But so moving on, Table 2 has...
Excuse me, Eric, one more question. Senator Peterson.
Thank you, Mr. Chairman. You use census data on this. Did you make any attempt to get the number of licensed drivers in each county?
No.
Okay, thank you.
Now you may proceed.
We did actually have, we thought of that when it was too late to include it. So, but I think, that it's a good point that the percentage of the population that may be driving can kind of affect how these numbers should be interpreted. So Table 2 is the same thing, but for any suspension that a court sent to KDOR, it's the number of charges associated with that suspension. So in any given ticket, somebody might have 3 or 4 offenses. I think it'll be most useful to come back to this in the summary statistics where you see the average number of charges per ticket. And there's a corresponding map on page 7 for 2022, the number of charges associated with suspensions per 1,000 residents. And in general, it looks like they correspond with the number of suspensions. So in general, it makes sense. The greater the number of suspensions that you have, the greater the number of charges that are being associated with them. Table 3 on page 8 shows suspensions, the charges, the charges associated with the suspension broken down by the statute that is cited for the violation. So table 3 is organized, ordered by the statute number. So if you wanted to look something up by statute, this is where you might want to look. The next page, on page 10, table 4, is the same data, but ordered by the most common offenses. So you might find this more useful in terms of how to think about this. It basically shows any offense that has 10 or more suspensions associated with it, or charges, number of charges, and then kind of groups everything else into a single category on the last line of the table. So as you can see, this is in 2022. The highest ranked offense was exceeding maximum speed limits. There were 13,000 charges for that, which is about 29% of the total. 14% for driving while license canceled, suspended, or revoked. 12% for operating a vehicle without liability insurance. 7.5% for operating a vehicle without the proper or valid license. 7.25% for illegal or improper registration. A little over 4% for failure to wear a seatbelt. 3.6% for operating a vehicle with no or expired registration. 2.5% for DUI, and 2.14% for failure to carry or display license, and then they go down from there. On the next page, for the same set of data, it's broken down by the number of suspensions for any given case. So a case could be associated with an individual and have multiple suspensions occurring in the same year. If they're not showing up and paying their tickets, and they get another ticket and they don't show up and pay that one, that would result in a second suspension notice being sent to KDOR. The table 6 shows the charges that are associated with a suspension based on the number of charges. So you have some instances where you had a suspension. There's one instance where a suspension had 29 charges associated with it. And there are, the majority, 30, not the majority, but about a third have one charge. About a third have 2 charges associated with the suspension. Table 7 on page 13 shows the cases, the number of charges per case. So there are fewer cases than there are suspensions because some cases have multiple suspensions. I'll sort of maybe mention something about that in the summary statistics. Table 8 on page 14 shows, so this is beginning the Department of Revenue data. So these are municipal court suspensions for failure to comply with a citation by county and municipality. And then suspensions per 1,000 residents for those cities that are included in this list. And then the map on page 19 shows those municipalities, the relative number of suspensions per 1,000 residents across the state. You'll notice there's a big blue dot in Sedgwick County. That is Eastboro if you go to page 17 on the preceding page, Eastboro, they have 746 residents. That's their population, but there were in 2022 436 suspensions for failure to pay a ticket. So for every 1,000 people, you have over 500 suspensions. This is indicative. There's a wide variety of situations like this, again, where just the nature of a particular area and the population differences and how policing and courts are working through these things can have a big influence on those things. So it's difficult to make hard distinctions about this.
Senator Faustido.
Thank you, Mr. Chairman. Eric, so I drove through Eastboro yesterday, as a matter of fact. And so it's a little town, it's a community within the surrounding community of Sedgwick County. And everybody drives through there to get to the mall. And you have to slow down at exactly 20 miles per hour. And they have their own private police there. And if you go 21, then you're stopped. So, Mr. Chairman and other members of this committee and those listening, that's another part of this issue, is that a lot of people don't know the difference that when they're in Eastboro, that's a whole nother entity. They may get that ticket and they don't know that they need to go to that separate court there because they've got a little city hall in that area themselves. And so, Mr. Chairman and others listening, somewhere we need to help people know that while they think they've paid off their fines, they need to look and see if they've received a ticket in another little county or entity. And I don't know if that's specified within our laws or in your presentation at all, Eric, is it?
I don't have anything specifically, but I do know that individuals can request copies of their own motor vehicle records, and they would be able to identify if they have any outstanding suspensions or citations. One thing I would note that is important regarding Adam Sievers' presentation, there are a lot of citations for things in this list that are not included in the traffic citations that can be that are handled in district courts. The citations that Adam mentioned, I believe, primarily refer to state statutes that are handled through the district courts. But 8-2110 says that it also includes citations for municipal courts. And we heard Conferee testimony that people are that this can occur to them as a result of municipal court violations. What I find in this data is consistent with that. And there are a number of things that I think anybody would probably agree are real traffic related violations that are not listed as offenses at the state level. So things like driving with expired tags. There is a state statute that has requirements for license registration and plates, but there's no penalties in the state statute for there aren't specific offenses. But what you find is that in municipal courts, in their codes, there's a book produced by the League of Municipalities that is something like standard traffic ordinances for Kansas cities. And most municipalities follow that and then make their own amendments to it as needed. But there are many things in that, like driving with expired tags, that can lead to a municipal citation that then would put somebody into this category. My understanding is that any municipal traffic, anything that's in a municipality's traffic ordinances that is a citable offense could also result in this process. And in the data that we have, there are, in Adam's list, I think I counted something like 215 statutes. In our data, we have most of those 215 represented, but then another over 100 statutes that are not in that list that Adam presented that are being violated. It's hard to make determinations about what that means, partly because those offenses might just be associated with a ticket that somebody didn't pay. So the suspension's for not paying something else, but then they also had another, it's difficult to say that that's the actual reason why not paying resulted in a suspension. But I do believe that violations of municipal ordinances can result in suspension if you don't pay those tickets. I don't think we really have time to go through much of this in more detail. I would just maybe go to page 22, the map number 4. It's a map of motor vehicle records of suspensions that took place in 2022 on drivers' motor vehicle records. These are drivers that have a suspension for not complying with a citation. As a proportion of suspensions in municipal court versus district court. So the higher the number just means that more of these are coming from municipal courts. So if you look at Johnson County, 81% of failure to comply citations are being adjudicated through municipal courts, which would mean something like 20% is going through district courts. But out in Trego County, you see 6.5% are occurring in municipal courts versus district courts. So a lot of that is just the nature of where cities are more populous. They tend to have larger municipal courts. Number 10, table 10, I think is useful. Page 23. It shows the number of court-ordered suspensions, the total, so either municipal or district courts in 2022, and then the number of residents within a county that have a suspension. So not every suspension that's ordered by the court is for a resident. And then the right column shows the proportion of court-ordered suspensions in the county compared to the number of residents that have a suspension. So in that rightmost column on page 23, if the number is greater than 1, that means a greater proportion. There's more suspensions ordered by the court than there are residents that are being suspended. So if you look at Coffee County, in the second column, there are 325 suspensions ordered by the court, but 110 of their residents actually have a suspension. So that's why in the rightmost column, there's 3 times as many suspensions in the county as there are residents that have a suspension, if that makes sense. And then a corresponding map of that on page 25. And then there's 3 maps that correspond to that table on page 25. On page 28, there's a breakdown of the number of drivers with suspensions based on the number of sanctions that they have on their record for failure to comply with a traffic citation. So 127,000 drivers at the time were revoked or suspended for failure to comply with a citation. Or they were revoked and they had sanctions for not complying with a citation. And you can see, the majority about half have 1 sanction. And then in table 12, we looked at conviction data. So you'll note that of the 127,000 drivers who at the time had a suspension or revocation, about 88,000 of them did not have any convictions on their record at any time. And then about 17,000 had one conviction, that's 13%, and then 6% had two convictions on their record. But the overwhelming majority of that population don't actually have any convictions on their record although they have their license suspended or revoked. Excuse me, I made a mistake. This is major moving violations. So these would include things like DUIs, not having insurance, driving while suspended. On the next page, on page 29, you can actually see a list of the types of violations. So major moving violations and minor moving violations or non-major commercial vehicle violations. These are groupings that are that the Department of Revenue makes. So major moving violations includes driving while suspended, DUI, not maintaining insurance, refusing a chemical test, various personal offenses like hit and run, aggravated vehicle battery, or vehicle battery in general. Those sorts of things are in major moving violations. So of the people who have a suspended license for failure to comply, about a third of those have a conviction for driving while suspended. And then for minor moving violations, you can actually see the number is much lower. There's of all the convictions on people's record that are in this population, only 5% have only 3.8%, or I guess 4.8% have a conviction for speeding on their record in the group of individuals that currently have their license suspended.
Are there any questions? Thank you. Very extensive, and whoever did the work behind this needs to be thanked a lot. There's a lot of data here. Are you ready to move on with the committee suggestions and all that?
Yes, Mr. Chairman, if there are no questions about this, yeah.
Yeah. Excuse me. We do have to, I want to remind everybody that I want to thank the conferees that came to remind the body here. Melissa Bayless, Office of Judicial Administration, is here to answer questions. Ed Klump, of course, with the Police, Sheriff, and Fire Associations. Lacey Black with the Drivers KDR. Micah Temple, Kansas Legal Services. Marilyn Harp, Kansas Legal Services. Commissioner Jim Howell's supposed to be online, and possibly others. And committee, we can ask questions of them if you have any as we go through. They made specific recommendations and presentations at our last meeting. So with that, I wanted to highlight the fact that we're here, and I appreciate your patience this morning for being here, and thank you for being here. Eric, the next step you want to do is go through the committee suggestions. Or I can read them either.
Thank you, Mr. Chairman. I think that the plan on the agenda was to have space for committee discussion and any recommendations to the legislature or to future legislatures regarding this issue.
Right. You heard what Eric said, and we will go through these committee recommendations and also recommendations from the conferees. Is there any discussion right now or questions you have for the conferees that did appear or that are in the audience? Senator Pasquito.
Thank you, Mr. Chairman. My question is for Lacey Black with the Department of Revenue, Drivers Control. Is she here? So if you could just share, because again, the original intent of Senate Bill 2 was to help individuals who didn't have a DUI, individuals who just didn't comply because failure to pay, and also is to allow those individuals to be able to drive back and forth to work, and um, um, but it became difficult if they didn't pay in the first place. And then if you could just share and explain for the committee and those listening in, um, so the program that we already have for suspended drivers, and if you could share a little bit about, you and I were together in Wichita on September 16th, Mr. Chairman, and we had the restrictive driver's license workshop with our Wichita Police Chief Sullivan was there. And Mr. Chairman, I want to report that he is doing something proactive. He has instructed his officers to, if they do stop someone for running a stop sign or speeding, that they would make a point to circle the telephone number at the bottom of the ticket and let people know that they can call that. If they don't have the money to pay, they can call that number immediately and set up payments to prevent this. So if you could just talk about the reason that revoked drivers, when they apply for the restrictive driver's license, uh, why they aren't granted that, or just how that process works in your department. Thank you, Mr. Chairman.
Yes, thank you, Senator. So currently with the restricted process, the restricted license process, the only drivers currently who are eligible are just the drivers who are suspended on unpaid Kansas tickets. So if you have any other suspension or you're revoked, you're not eligible, you're denied. So the Senate Bill 2 that Senator Falscadeau has previously proposed, it would open it up to drivers who are now revoked for driving while suspended only. So they can only have the 3 driving while suspended convictions that have now put them in that 3-year revocation period. It would open eligibility up for those drivers to have the restricted privileges. And then, yeah, we would have to kind of look at the administrative process to decide, as Eric said earlier, someone who is revoked, their privileges have been completely terminated. So they do have to go obtain a new license. So we would have to determine if we want to do that before we give them the restricted privileges, or go ahead, put them on the restriction, and then have them do the testing and everything at the end. We would have to determine how that would work, but yeah, it would just open up that eligibility for more drivers. We would be looking in our process at Driver Solutions, we would be looking, making sure they only have those driving while suspended convictions. And then on top of that, how it was currently proposed and written is at the time of the driving while suspended, they could have only been suspended on unpaid tickets. So if there were any other suspensions other than unpaid tickets that put them into that driving while suspended conviction, those drivers would not be eligible. So it's a very detailed, specific population of drivers that we would be looking at, but it would give them an option to drive instead of just being revoked for that 3-year period.
Thank you so much, Lacey. Thank you, Mr. Chairman.
Representative Francis.
And so I sometimes get confused because of the number of issues that we talk about in this committee. So Senate Bill 2, it applies, is it right that applies to about 1,670 Kansans as a whole?
Yes, Representative. I believe the last time I pulled the statistics on those, it's obviously changing every day, but yes, it was between 1,500 and 2,000 drivers that how it was currently proposed that would be eligible.
And just help me to understand, I know Eric, when he gave some of his information earlier, can these 1,600, can they contact their judge and whoever they're coming before, and can they set up a payment plan and get some of these multiple violation fines reduced and apply for a restricted permit under current statute? Is that within the judicial discretion?
Yes, thank you. Under 8-2110, there is discretion in there for them to have fines or fees waived through the court. So yes, if they have unpaid traffic citations, they would be able to ask the court to amend what they currently owe.
And they can get a license, or they can't get a license even if they set up a payment plan?
If they're currently revoked,
Yes.
no. Currently, no. They are not eligible for any restricted license, even if they are set up on a payment plan. If they're in that revoked status for habitual violator, currently there is no option for them to drive.
So the very fine issue here is those 1,670 that even if they set up a payment plan or anything, they can't get a restricted license even if the court wants to allow it.
Yes, that's correct.
Okay.
I have a question, Lacey. Thank you for being here. And now, with a lot of the recommendations that we have heard from the committee and also from conferees, has that expanded that population from the number?
Yes, Mr. Chairman. So with what I've heard, yes, if the bill is amended or changed to how Senator Falscadeau proposed it, then yes, there would be more, the population would be bigger that would be eligible for the restricted license.
And I have one more question, if you'd be so kind. It seems to be there is a lot of confusion about SR 22s. Could you kind of give us a basic outline of an SR 22, the history and what it does? Thank you.
Yes, thank you, Mr. Chairman. So the SR 22, it's an insurance form that is required for certain convictions or suspensions. So DUI, driving with no insurance, reckless driving, those are just a few of the main ones that we see. Those convictions in turn require an SR 22 to be held for 1 year. So KDOR sends a letter to the driver letting them know that because of this conviction, you now have to carry this SR 22 for 1 year. They go to their insurance provider, and if they currently have a policy, it's in addition to their insurance policy. So it's something extra that they pay for, and then KDOR receives the form, and we track it, make sure that they keep it for 1 year, and then they can cancel it off of their policy after that. Also, if someone does not have an insurance policy because they do not own a vehicle, they do have non-driver or non-policy SR 22 forms. So as Senator Falscadeau said earlier, that yes, if someone does not have a vehicle, they may still be required to carry that SR 22 form, but it is in addition to a policy.
Thank you for that. Representative Carlin? Okay. Representative Francis?
And the chairman is much wiser. Of course, he's known that for years, that he's much wiser than I. So help me again. I understand what is thought needs to be done for the 1,670, and I understand the SR 22. If we broaden the population more, what are some of the policy considerations that are affecting that broader population? Is it some of the citations that maybe have nothing to do with licenses? Are those some of the things we're considering? And maybe the chairman is better able to enlighten me.
Well, my opinion is if we adopt, we're going to have some recommendations, and if those recommendations are adopted in a bill form later, remember now, we are not building a bill here. We're just making recommendations for our future chairman or future carrier of the bill to request a bill. Uh, some of the waivers, some of the, it goes a little broader in some of the fields as it relates to traffic violations. It changes it from 3 to 2 offenses. Those kinds of things creep into a broader population.
Thank you.
Are there any other questions? I think for the expediency of time and to show appreciation for our conferees here, excuse me, Senator Peterson.
Just a quick question. I don't done it before. It was regarding Ed Klump's recommendation on the failure to pay all fines versus the failure to pay fines as ordered by the court, which kind of encompasses our current practice. Do you have any comments on that or any of the conferees?
Thank you, Senator. So, are you talking about when he recommended them going straight into a restriction instead of suspension for failure to comply?
No, I remember that when I was talking about when the order to pay. Right now, the bill, Senate Bill 2 says to pay all fines. We should consider changing it to pay fines as ordered by the court. Failure to pay fines is ordered by the court.
Well, currently, KDOR, we would only take action on a failure to comply that we receive from the court. So, if they don't,
I don't know that you would be the conferee that would need to answer that.
Okay.
Mr. Klump, would you please come forth and identify yourself?
Morning, Ed Klump. I'm represent the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. Senator Peterson, that recommendation is just covers a topic that one of you mentioned earlier, and that is whether the fine has to be paid in full before the license is reinstated. And I think that's an area that, in my conversations over the last several years on this issue, is handled differently in different courts. And when the state says paid in full, in the statute, then I think that leaves the door open. If you're on a payment plan, making your payments, that you could still be suspended under that statute. And so my recommendation was merely to clarify that, so that if a person is following the orders of the court on their payment, then the statute would allow that latitude to where that wouldn't be suspended, could not be suspended, as long as they were in compliance with the court's payment plan or whatever plan they set up.
I really like that recommendation. I think it kind of encompasses what the courts are trying to do now, some of our courts.
This topic is one our association have dug into pretty deep in the last few years, and this is one of the areas where I think there needs to be clarification. Our feeling is, if a person is in compliance with a payment plan, they're following their payment plan with some allowance and deviation, which is going to happen, then we don't think they should be suspended. If they're making an effort to be right with the court, they shouldn't be suspended. That's our belief. If they're just refusing to work with the court to get right, then that's a problem, and we don't have a problem with suspending those. But we also kind of bleed into the other topic. We believe that doing those restrictions first and then the suspension later if they don't comply is probably a better process.
Thank you.
Committee, Senator Fascido.
Thank you, Mr. Chairman. Ed Klump. And Mr. Chairman, I certainly agree with Senator Mike Peterson's comment in the recommendation here. It would certainly help so many people. So do you think that this recommendation also would help with that 3-year waiting period? I know several people that have paid their fines off, met court obligations. And so they lose hope when they do that, and then they still have to wait another 3 years before their driver's licenses are reinstated. So would this issue also address that? What do you think?
We believe that if you go to the restriction, that it will help that, because our understanding, and Lacey will probably have better information on this, but my understanding is many of those that get into that situation where they get their fine paid, then they can't get their license back, are then either suspended or revoked because of the driving while suspended violations. So if a person is given a restricted license and they, let's see, if they get a restricted license and they abide by those restrictions, they're never going to get a suspended driver's license violation to that. If they do by chance violate that and get caught, one of our recommendations that became law now, that we made several years ago, was to clarify that if you're driving on a restricted license while it's suspended, in other words, you have the suspended license, but you allow them to drive with restrictions, that is a violation of a restriction violation, not a suspended driver's license violation. And our intent in that was to soften that as well and to eliminate those. But it's complicated, and Lacey get better into that better than I can, but it's complicated because there can be many reasons that you're suspended. Even after you pay off these fines, you may be suspended for other things, DUIs, failure to, maintain insurance that the fine's paid on, that still carries a suspension with it. And even then, we have the provision, which I think is a good provision, that if you have multiple convictions for driving while suspended, then there can be an extension in that suspended period. Well, if a person's ignoring the order of suspension and driving anyway and getting caught repeatedly, that you shouldn't just allow that to happen. And so we believe that's a good provision, but it's a question of if we can modify this in a way that the person's on a restricted license versus a suspended, then you eliminate those driving while suspended convictions that lead to that problem. But that is just one category that leads to that problem, that they can't get a reinstatement.
Okay, committee, I think what we'll do, you've seen on the report handed out by the KLRD, we went through the informational specifically requested by the committee. Eric went through that very carefully. We'll now go to the committee suggestions to consider for review. Now, the committee, these are suggestions from the committee, and they are as follows. Consider a change in the suspension process or allow for an initial period in which a driver's license would not be immediately suspended. That was a committee recommendation. Explore the possibilities of providing for repayment plans and improve communications between the Kansas Department of Revenue and the courts. And I think we have heard evidence of that is not clearly defined. Some are using the judicial prerogative and some are not as much. Review traffic citations that could be excluded from citations that, if not paid, could result in driver's license suspension. And again, most of these topics will take considerable more research to be more specific. Consider limiting reinstatement fees to a single administrative fee per reinstatement rather than a reinstatement fee for each charge. And I think that's pretty clear. That's been an issue, contention. That was a committee recommendation. Consider providing judicial discretion with regard to suspension and revocation, and review the requirements that certain drivers maintain the SR 22 insurance requirement. And again, those were committee recommendations, and I think for the report by acclamation, we sure want those committee recommendations in that final report. Now, the next section we're walking into here is the Conferee recommendations. And we'll go through these step by step. Conferees made recommendations to the committee with regard to the following. SB2, clarify language in SB2 as to whether habitual violators are included, and include SB 22 cross references relevant to statutes KSA 8-285 and KSA 8-287 to help clarify the target population. And again, that kind of gives us a better handle on of the total approach. Any questions on those? Those are recommended from the conferees. If not, we'll go to fines and fees. Establish a historical cut. Just a moment, excuse me. I was just reminded the committee recommendations. I made the move that we would adapt those by acclamation. However, on the conferee recommendations, I will entertain a motion approving each one of these recommendations. So the first ones I read over were the ones about SB2, clarified language in SB2 as to whether habitual violators are included, and include in SB2 cross-reference to relevant statutes as I stated before. Do I hear a motion to approve that recommendation? Senator Fausto made the motion. Is there a second? There's a second by Senator Peterson. Any discussion on that recommendation? What we're discussing here is these recommendations by conferees obviously will take additional research, additional study. And these are more conceptual than being specific. Eric, do you have a comment about that?
Yeah, thank you, Mr. Chair. I think the purpose of this document was just to sort of review the things that the committee had heard before. It's up to the discretion. It's up to your discretion how you want to proceed. But if you wanted to entertain motions from the committee regarding things that they might be interested in recommending, that could be an option as well.
Thank you, Eric. We can approach it from that point of view. Looking down through we still have that motion on the table. I think I'll ask for a motion to withdraw the motion.
I withdraw mine.
And Senator Peterson, withdraw your second. We'll take that off the table for now. Let's go down through this. Look at the ones that you feel strongly about. And if you would like to make a motion on, for example, establish a historical cutoff of outstanding fees, please feel free to make that motion.
Mr. Chair,
Yes, Senator Francis, or Representative Francis.
thanks for the promotion. I am house trained. When I look at some of these things and when I think about the testimony that we heard, some of what strikes me is that maybe some conversations need to happen, or a recommendation needs to be that more conversation needs to happen with the courts. It sounds like we have judicial discrimination judicial discretion that would allow the courts to write off some of these fines and limit some of this, onerous penalties that maybe some people don't have the means to comply with. So I guess one recommendation I would have would be to get the Judicial Council to have some meetings, on how we can encourage more judicial discrimination, address some of these discretion. Did I say discrimination again? Shows what I may have some subliminal thoughts about the courts on occasion. Uh, School funding. Um, uh, anyway, I would like a little more input from the courts on how we can encourage more judicial discretion uh, to address some of these issues.
Is that a question for the court's conferee right now?
I don't know if it's a question or more of what one of our committee's recommendations. Maybe the court would like to address that.
Yeah, Marisa Bayless, Special Counsel to Chief Justice Luker. I was just going to note, I know we were talking about forms and applications. Our Access to Justice Committee is currently working with the Judicial Council to make a standardized application form so that it will be the same form that will be used throughout all the judicial districts for the request for a waiver or reduction of fines. So we are working to have something that is more standardized, so at least what is presented in front of a judge is the same thing in all districts.
And can I ask you a question?
Yeah.
Is the language that's in the existing law that says the person must petition the court,
Yeah.
does that create some of the issue here as far as the judges don't first grasp on that?
So anecdotally, when I talked to our judges that do traffic dockets, and I specifically looked at our highest, so Sedgwick County, Johnson County, the large traffic dockets, they told me that what they get most of the time is just payment plans, and the way they conduct traffic dockets, because they're so large, they're long, that to get through it, a lot of them are just asking for a period, a date. So a person comes in, they say, this is the amount you owe. When can you get this to me? If they say 3 months and that seems reasonable to the judge, they may ask them some questions informally. A person's not coming to traffic court with an attorney, most likely. So it is just a conversation with the judge. I mean, it is their determination and their discretion there to say, okay, 3 months is fine. Here's your pay or appear date. If you don't pay it by that end of that date, you have to come to court. Where we see the problems is people not coming to court that second time. And at that point, the judge doesn't have any information of why that person's not coming to court, if there's a valid reason why they haven't paid. So then the non-compliance is set. And there's not really judicial discretion to be exercised if we don't have a person there to talk to.
So you don't think the word petition creates any kind of issue for judges
I don't
that maybe
think
don't have as
so.
big a traffic court or don't deal with that on a day-to-day basis as much?
That's not what I heard from them, I would say. Yeah, that they don't necessarily see it with that. When it would come, though, to an actual waiver of fines, I think from my understanding of talking to those judges, having this form available for a person to fill out would be most helpful, because they are trying to have to make a determination of manifest hardship. So having something that is more standardized that we're working on, I think would be helpful for those judges who are considering a potential waiver of all fines or fees potentially, because that is in their discretion to do.
And so I may want some of the leadership of the committee to give me some thoughts on this, but I would like to have a report sent to the legislature about the progress on this universal waiver form. And I guess, Mr. Chairman, I would make a motion that one of our recommendations be that we receive a report on the progress on the development of this universal waiver form. I'm not sure what committee it would be appropriate for it to go to, whether it would be the House Judiciary and Senate Transportation Committee, or again, I'm not clear on the appropriate committees.
So you would frame that as a motion to make further study on that specific.
A motion for the judicial count, is it the judicial
It will
council?
be a judicial council form, but OJ is working with them on it. So.
From judicial administration on the progress to develop a universal waiver or payment form.
Correct.
Report that back to the legislature. I'm not sure where though to report it to the legislature at.
Well, we wouldn't know. That would be up to the assignment of leadership as to what committee that would go to anyway.
Okay, the report to the legislature.
We can do that.
Did you hear the motion, Senator Peterson?
I'll second that motion.
Senator Peterson seconds the motion. Any further discussion on that motion, Senator Vascato?
Mr. Chairman, if I start to call you Senator too, if Representative Francis doesn't mind, I'd also like to add in there to make the distinction of a judge just allowing a person to make a payment in that 3-month period that you stated. However, with Senate Bill 127 that passed into law, that petitioning the court, to my understanding, is where a person fills out, shows their inability, their hardship to pay, and then they get they might get a reinstatement fee waived, etc. So I'd like to get the distinction between both.
So that form should be to cover everything in that. So a waiver, a modification, or a reduction. So that would be the intent of that.
Yeah, that's fine.
Yeah.
Yes, Senator Dietrich.
Thank you, Mr. Chair. Would it be possible to set a date by which we might receive that report?
Is there a date that would be good?
They're hoping to get it done by the end of the year, so we should have it for the next legislative session to report back.
At the beginning of the 2024 legislative session.
So amend your motion to include the date. Okay. Representative Carlin.
Thank you, Mr. Chair. I just was going to make a comment. I support the motion because I think it does sound like that we already thought about that instead of Bill 127, which I don't remember, but this will give a record that there was an application and the actually what the judge decided and also the rules that go along with it will all be a matter of record if they do it through a form, where if they just call the office or go and see the judge, that I don't know what kind of record, but the standardization would be really helpful, I think. And it will give both parties a reason to comply by having their signature on it. Good idea. Thank you. Thank you, Mr. Chair.
Thank you. Is there further discussion, further questions? You've heard the motion, you heard the second, and the discussion. All in favor say aye. Aye. Those opposed, same sign. Motion passes. Senator Pasquillo.
Thank you, Mr. Chairman. So I think you guys or the members also recall that the Wichita Racial Profiling Board had a workshop on September 16th there in Wichita. Our police chief was there, Lacey Black came, and others were there. And we had, Mr. Chairman, you had asked for the numbers of that attendance there. We had a total of 230 people showed up. 147 attendants signed up to see an attorney. We had pro bono attorneys there who 40% of that 230 saw an attorney. 72% of them had suspended licenses, and 28% of those 230, their licenses were revoked. And so hearing from those individuals who were there and wanted to make payment, they wanted to be a law-abiding citizen and they just want to get to work. But they are discouraged when they hear about waiting 3 more years. So I would make a recommendation that we strongly look into, and I'm not sure, Mr. Chairman, if it's already listed in the other recommendations, but whatever language our staff, our wonderful Adam and Eric Ian can come up with to address eliminating that 3-year suspended or 3-year waiting period would be a strong recommendation from me, Mr. Chairman.
That is a valid request. Can you help us with the verbiage of that, Eric or Adam, to make sure that we have it properly stated? Yes, Eric.
In terms of any kind of future drafted legislation, that the specifics of that language could be discussed with the revisor's office. But for purposes of the committee, you could say something like recommend that future legislation on this topic provide for reinstatement of revoked licenses for drivers who comply with, something along those lines, like provide for drivers who have a license revocation due to driving while suspended only for non-payment of or non-compliance with traffic citations, that their licenses, that they be eligible to have full driving privileges reinstated upon compliance with the original citations.
Is that okay with you?
Mr. Chairman, if I may, because I really like Montana's piece, if Montana laws provides discretion to the courts to order payment plans for the traffic citations, and if that driver is complying with providing insurance, signing documents to pay, that their driver's licenses not be suspended and reinstated if they are following those terms, eliminating that 3-year waiting period. So I'll take whatever you will send us.
The difficult thing with that is that whether you want it to be related to the judicial court orders for payment plans, whether you want to have it tied to judicial discretion or just kind of a blanket recommendation that if drivers are complying with the citations that they've been suspended for, that they should have their licenses reinstated, something along those lines.
It appears, Senator Faust-Godot, that you're adding two separate different subjects here. One is a payment plan, and the other one is the 3-year.
So, if I may, Mr. Chairman,
I thought we already addressed the payment plan issue. I'm talking about the 3-year additional waiting period.
So if I can try again, maybe using the language of SB2. So what I understand is you want to allow individuals to get full driving privileges back once they've paid all their fines, fees, and court costs, right? So using the language of SB2 or the definitions in statute for that population, an individual whose license has been revoked solely for driving while their privilege to do so was canceled, suspended, or revoked for failure to comply with a traffic citation. The recommendation is that they have their privilege to operate a motor vehicle restored once outstanding fines, fees, and court obligations have been met.
Mr. Chairman, that sounds good. And I know that we're just making recommendations. I know that legislation will be introduced and we'll tweak it. I mean, some other lawmaker might say, once they do that, they still have to be on some little trial period to make sure that they have made consecutive payments or they're getting near their full payoff. I'm perfectly fine with the way that you have wordsmithed it, Eric. So, thank you.
You have heard the motion modified and approved by Senator Fasquedo. Is there a second? Representative Melton, second. Any further discussion? Seeing none, all in favor say aye. Aye. Those opposed, same sign. Yes, Representative Chairman Patton.
Thank you, Mr. Chair. Just to make it clear what's going in our report as a recommendation or not, I would like a motion to make a motion on the items in the report that we've been looking at on the first page where it says committee suggestions to consider or review that the chairman went over a little bit ago. I'm going to make a motion that this committee believes that those items do need further study and review by the appropriate legislative committee.
You have heard the motion. Is there a second? Senator Representative Neely, seconds. Further discussion on that issue? Seeing none, all in favor say aye. Those opposed, same sign. And if you'll recall that the chairman, I used the prerogative to acclamation, and this now formalizes it in a specific motion. Representative Patton, do you have other motions?
I don't yet, but I'm trying to think of some.
Again, committee reminds you, and I think you know this, I've said this too many times, this report, regardless, will be in the record for future legislators to review, regardless whether it's been adopted or not. So that will give you some guidelines for that next piece of legislation. Are there any other recommendations as it relates? Senator Peterson.
Thank you, Mr. Chair. I'd like to recommend that we have one of the committees consider requesting the Judicial Council review traffic violations that could be excluded for grounds for suspension.
Okay, would you state that one more time, please?
I would like to recommend we have one of our committees look at requesting the Judicial Council review traffic violations that could be excluded as grounds for suspension for failure to comply.
Okay, you've heard that motion. Is there a second to that motion? Representative Carlin seconds it. Is there any further discussion? Seeing none, all in favor say aye. Those opposed, same sign. And that has been a point of discussion. So that is a good, solid recommendation. Are there other specific recommendations? If you have, I'll give you a few minutes to review down through that list that were Conferee recommendations. But again, like I said before, it will be part of the permanent record as to items that were discussed. Senator Fasquedo.
Mr. Chairman, I have a question for you, actually. I know that we, on September 29th, it was clearly made that we have options for those with a DUI. They have options to whereas they still keep their driver's licenses. And so of your recommendations that are listed here, which one clearly allows for some provision to allow a person who simply could not pay the ticket in the first place and it snowballed? They've not committed any major crime, but they just can't afford to pay. Now, yeah, they took a chance. Heck, they had to go to the doctor. They had to go to work. They took a chance to drive. Now they're in a revoked status. And I just simply want them to be able to apply for a restrictive driver's license for 12 months while making payments on their fines. If they miss it, heck, they're out. But what do we have to allow a person with a revoked driver's license because they were driving while suspended to get their driver's license reinstated? Mr. Chairman, I want to say this. I actually have went to the court where you have to go at 6 o'clock in the morning. You have to stand outside in a long line to go in to see a judge, and they cut them off. They might do 22 people a day, and you'll have a line out there of 150 people. And yeah, there are provisions where the court can allow discretion, but they can only take so many per day. And so what else do these people do? We don't have a good transportation system. Adam, Eric, Darren, Mr. Chairman, anybody. I'm just trying to allow a provision for a revoked driver, an option just like we do for DUIs, to be able to get their driver's license, to get on a, we've got a lot of moving pieces here, but we're not saying anything specifically to allow the revoked driver to participate in anything yet. Thank you, Mr. Chairman.
Good question. And I was looking through the recommendations and I did not see anything that specifically addresses your concern. So if you could frame your recommendation again, I thought it was a good thought process.
Mr. Chairman, I was asking all this research and all this data and information of thousands of violations and different options we've had. They've included DUIs, they've included, reckless driving, a lot of things. I understand that. I get that. Senate Bill 2 was simply to allow a person who had been driving while suspended to participate in current law, where they fill out an application, they sign it, what recommendations do we have for that? Otherwise, to me, this whole meeting has defeated the purpose if we're still not going to have an option for Kansans with a revoked driver's license who have done nothing but just the failure to comply to pay the ticket.
I'm trying to think about how we want to frame that motion. Eric, do you have a suggestion?
The committee could consider making a motion on the provisions of SB 2. Something along the lines of making a recommendation, recommending it favorably to the legislature, something along those lines, or that the legislature pass or consider legislation that would enact provisions substantially similar to those in SB 2.
I like that part. Yes, Representative Francis.
I'm sorry, maybe the senator can explain to me. I'm not understanding the difference between what this motion is versus the one that we discussed that you brought forward maybe before the last one. I'm trying to understand what the difference is.
Senator Vasquez.
And thank you, Mr. Chairman, and I'll clarify. So we've made some great recommendations, and the recommendation, Representative Francis, that you just made kind of deals with the court procedures. We've also made a recommendation to eliminate, right now there's $100 per fine per reinstatement fee. We've made that recommendation to kind of combine that or to eliminate the $100 per traffic violation. So we've also made a recommendation that if you were to pay your fines and make your obligations with the court, and we've addressed the 3-year waiting period. We've addressed the 90-day additional waiting period. But from what we heard from Lacey Black from the Department of Revenue, Driver's Control is still saying that even if you pay your fines, and you submit the application to driver's control, because most people are not, I know some people who I saw on September 16th, Mr. Chairman, they have $15,000, just fees and fines have accumulated. There's no way they're going to pay that. However, Representative, I'm just simply saying to help them make those payments if they can't, even if the court eliminates the $100 reinstatement fee. And we also have something in our courts in Sedgwick County where you can do community service that will reduce some of those fees, but you still can't drive legally. So my main intent from talking to real drivers who are dealing with this situation, they just want to apply for the restrictive driver's license program that already exists in the Department of Revenue and be allowed to drive back and forth to work and school while making payments on their fines, just like we allow a suspended driver to do.
And I'm not disagreeing with what you're saying, as long as they're working on paying their fines back. I'm trying to understand. You'd made a motion about 2 motions back that I thought said the same thing, and I'm trying to understand the distinction.
Yes, Eric.
So what SB2 would do would allow individuals certain individuals whose license is revoked to apply for restricted driving privileges for the remainder of the period of revocation. The motion that was made was to allow those individuals to have their full driving privileges restored once they've paid all outstanding fines and court obligations. So the difference would be the group of people you could have your driving privileges restored while you're working on compliance versus once you have complied fully, being able to go apply at that time for a new driver's license rather than waiting 3 years or up to 3 years.
And so under current law, even once they pay all their fines and everything, they can't get their full.
For those drivers that have had their license revoked for 3 driving while suspended charges, there's a mandatory 3-year revocation period, regardless of whether they comply or not.
Right. And this one is different again than.
This SB2 would allow those individuals to have restricted driving privileges while the period of revocation is in place. The additional motion that was made by Senator Vascadeau was to allow them to actually to have the period of revocation end once they come into compliance, essentially.
Is that motion on the table right now? It. Well,
I don't believe there's been an actual motion for that.
There is a section here on Conferee's recommendation called license restrictions generally. Provide restricted driver's license for drivers making attempts to comply and be accountable. Limit the number of opportunities an individual has to apply for restrictions, and reform law pertaining to the failure to comply. Begin with restrictions with suspension subsequent to continued noncompliance. That kind of covers everything she's talking about. Yes, Senator Pascal.
Thank you, Mr. Chairman. So then my last statement, I withdraw and I insert the statement made by the chairman. Thank you, Mr. Chairman. That's it.
Well, it took me a while to find it. So that is a form of a motion. The recommendation under the caption license restrictions generally. Is there a second to that motion? Senator Dietrich seconds it. Is there further discussion on that? Seeing none, all in favor say aye. Those opposed, no. Thank you. That's the kind of discussion and that's the kind of motions that I'm looking for specifically. Senator Peterson.
Thank you, Mr. Chair. I'd like to have a committee look at the the areas that a person can drive to on a restricted license, make sure that they could drive to dropping off kids for child care while they have them restricted for failure to comply.
Is that in form of a motion?
So we,
So, and Senator Dietrich seconds. Any further discussion? That's kind of an add-on to the previous, but all in favor say aye. Those opposed, no. Motion passes. Are there other specific recommendations that you feel compelled or feel strongly about, or? Senator Fausto.
Mr. Chairman, and this is a question, not a recommendation. Maybe I'm not sure for the courts or Department of Revenue. So the application, did you say if they go to the court, it's only online, or is there a hard copy there as well?
Marisa Bayless, Special Counsel to Chief Justice Luker. So currently, right now, there's not a standardized form. What we would hope would that be, I would hope we would put it online or ask our district courts to have it on their website. Currently, right now, every district court runs their own website. The judicial branch doesn't control that. But if we have a district standardized form, we would at least hope to link to it to the Judicial Council's website or have, where it lives. So it would be online. There wouldn't be a like a online portal or anything like that to submit it. It would just be the paper copy form to print off and send.
Mr. Chairman, if I could make a motion to have the judicial branch look into that, because we heard that a lot of people from other counties drive through in and out different places. Would that be helpful to your department to make that request?
To
for that standardized.
So that's what we currently are working on.
Okay.
Yes.
Okay.
Yeah.
Very good.
From that previous.
Okay. Thank you. Okay.
Yeah.
Thank you.
Mm-hmm.
All right. Yes, Representative Francis.
And this might be a question that you could help me with. You guys are going to take care of your end of it, which is the district courts, or you're working on that.
Correct.
How do we encourage this to bleed down to across to the municipal courts? Is there a recommendation we need to make to the Municipal Court Judge Association along the same lines?
I would probably say that's up to you, but we as the judicial branch don't hold authority over the municipalities. So that would be a separate recommendation.
Mr. Chair, is there any kind of recommendation that makes any sense whatsoever to request the Municipal Court Association to review a policy, or to look at a policy that allows payments? Help me with this a little bit, Mr. Chair or Vice Chair.
Representative Francis, I think your concern is very valid. I don't see anyone here from the League of Municipalities, but I think a recommendation along those lines would be in order.
Maybe something where staff issues a letter to the municipal judicial staff to review municipal procedures regarding payments on restricted driving. I don't know. I don't have the right word.
I understand conceptually, yes. I think basically what you're saying is that you would like to have direct communication with the court system and the municipal court, so they're all on the kind of the same page. Yeah, that would be a fair recommendation. Is there a second to that motion?
There's your second.
Representative Neely seconds that. Any further discussion on that conceptual motion? Seeing none, all in favor say aye. Aye. Motion passed. Senator Falscadeau.
Thank you, Mr. Chairman. So not a recommendation, but I need clarification. And can I ask the Kansas Legal Service guy a question? I don't know his name.
Please identify yourself and welcome to the committee.
Yes, thank you, Mr. Chairman, and thank you, and Marilyn Harp and Kansas Legal Services. So earlier it was stated that you had some type of form online. Can you elaborate which application that was and how it works and what are people applying for? Thank you.
Hi, it's Marilyn Harp, Kansas, retired executive director of Kansas Legal Services, who wrote the form and put it on the website. So that's why Mike has stepped aside. As we saw, as the Senate Bill 127 passed, we created a form. I think right now we're the only place that form is available, but we are happy to provide it to the Judicial Council. It's simply a motion and an order that municipal courts or district courts can use to deal with fines, fees, and reinstatement fees, and really sets out for the judge how they have the authority to do that, because when new things happen, sometimes if a judge hasn't seen it before, he needs a little, like, where can I go to have this authority? So that's what's there.
So, Mr. Chairman, would it take a motion to allow for Kansas Legal Services to network with the judicial branch to address Representative Francis's concern? Or no? I don't know.
I think you just wrapped up a good motion. Is that a motion?
Okay.
Yeah. Is there a second to your motion? Representative Carlin seconds the motion. Is there any further discussion? Seeing none, all in favor say aye. Those opposed, same side. Thank you, Senator Falscadeau.
Mr. Chairman, if I may, could I just get clarification on what that motion was?
Senator Falscadeau, could you repeat that motion?
To allow or ask the Kansas Legal Services to share their application that's online with the judicial branch who's here in the audience. Is that okay?
Conceptually. Well, committee, are there other, again, this is probably the 10th time I've mentioned this, but everything that we have before us will become part of the final report. Even the formal motions that we made are formal motions. And the ones that weren't made, they'll still be in the report as it relates to the fact that it is of concern with certain conferees and certain members of the committee. So if your motion, or if you feel like a motion was left out, don't be worried about it. The concept will be in that final report. Seeing no other discussion, I want to thank the committee, thank the staff, and I think if anything we have learned here today in the last two meetings, it is a very complex issue. There's no perfect pattern across the United States that works perfectly. It is an issue with society and our whole system, and we'll just have to keep working on it. I want to thank the conferees for coming to the original first meeting, and I really appreciate you spending all morning here patiently, hoping someone would ask you one simple question. And thank you for being here. And before we adjourn, I want to recognize a gentleman that has given 10 years of his professional life to the Kansas Legislature and the citizens of Kansas, who has just recently tendered his resignation, and he intentionally tendered the resignation after this hearing, and that is Representative and Chairman Fred Patton. Would you like to say a few words?
I thought I was done talking. No, I appreciate that. Looking around this room, there's people out there in the gallery that I've worked with and have been a great help along the way. The staff, obviously, on all my committees, we can't do what we do here without it. And again, looking around this committee, it's a great way to reach my end because there's people here I've looked up to and have helped me along the way. So thanks, everybody.
Thank you, Chairman Patton, and we wish you nothing but Godspeed. And I've enjoyed working with you over the years, and a true great American and a true professional. With that, we're adjourned. Thank you.